This is Colin O'Keefe here for LXBN TV. The Supreme Court finally handed down its long-awaited NLRB v. Noel Canning decision, ruling that President Barack Obama's recess appointments to the National Labor Relations Board were unconstitutional. Joining me now to explain the justice's decision and its potential impact is attorney Seth Borden. He's with McKenna Long Aldridge, an author on the firm's blog, Labor Relations Today. Seth, first, can you walk us through this? Why did the justices rule the way that they did?
The Supreme Court, in its decision the other day, addressed three questions primarily. And first, what the court held was that the recess appointments clause allows the president to fill an existing vacancy during any recess of what they called, quote unquote, sufficient length. In doing so, they clarified that it can be either an intra-session break or an inter-session break. So it doesn't necessarily need to be the break, for example, between the 112th and the 113th Congress or the upcoming 113th and 114th Congress. It can be during the term of a Congress. It's just got to be, again, maybe they'll know it when they see it, break of sufficient length. The second question they answered was whether or not it could be used to fill vacancies that occurred only during the recess or that occurred or began prior to the recess and carried over into the recess, which was the case for the most part with these board vacancies. And the court held that it applies both to vacancies that arise during the actual recess and vacancies that carry over into the recess. And finally, and this might be the most critical point on the separation of powers issue that was at issue. The Senate is in session when the Senate says it's in session, and that the president has no right to determine whether or not there is a bona fide recess during which he can exercise the recess appointments clause. Now, the end result of all of this wound up being that the recess appointments, the purported recess appointments of these three board members were invalidated.
I see. And then second, what's the impact of all of this? Of course, as you mentioned, a number of cases have been invalidated, but where does this go from here? What is the impact?
Well, just focusing on the board, I guess we would say first things first is it doesn't really directly impact the authority to act. Most people recall last year in the midst of the fallout after the D.C. Circuit's decision and some brinksmanship over what was referred to as the nuclear option to eliminate the filibuster in the Senate, a political deal was struck whereby the full Senate confirmed 5 National Labor Relations Board members and the National Labor Relations Board's general counsel. So at least since that time that those folks were confirmed and seated late last year, there has been a fully functional board with a properly authorized quorum of members to act and a properly authorized general counsel. So the current board is able to act. Impact will truly cases that arose during that 2012 period and all of the decisions that were handed down during that 2012 period. There are a great number of cases that were handed down during that period whose viability is now been called into question. We're going to have to see what sort of procedural and logistical mechanisms the board proposes for the reconsideration of all of those cases. There may be hundreds, if not over 1,000 by some estimations of cases that will need to be reconsidered in some way or another upon request. And as a result, we've got some really serious and weighty issues in these cases that this board is now going to have to consider. And they're going to have to dedicate the appropriate level of consideration and really, I think, look at each of these cases anew now that they have 5 properly seated and authorized members.
I see. It's going to be very interesting to see where this all goes from here. As you mentioned, there's a number of cases that need to be reconsidered, and there's a lot that needs to be sorted out. So this very well may take some time to do. Once again, that was Attorney Seth Borden of McKenna Long Aldridge. For more of his insight on this case, be sure to visit laborrelationstoday.com. Thanks for joining me today, Seth.
Thanks very much, Colin.